What we want to discuss right now are the basic estate planning documents that everyone should have, whether you're married, not married, whether you have children. The four basic documents are, number one, a last will and testament. The last will and testament allows you to determine who receives your assets at death. It allows you to be in control. It allows you to designate how and when different heirs receive your assets. We can create a testamentary trust. We can do all kinds of things in the will, and you can determine how and when everyone receives your assets. In the last will and testament, you designate an executor. We call that a personal representative in South Carolina, and that person administers the will after you're gone to make sure that your assets go the way you want. The personal representative doesn't have the authority or discretion to change the will. They're simply taking your instructions and making sure that they're followed through. One of the things that the will does is it has a very powerful thing that allows you to change your will after you leave the office. So let's just say on November 1, you sign your last will and testament. There is a written memorandum that allows you to take your will and amend it after the fact. We'll have a video on that shortly. So document number 2 and document number 3 are called healthcare proxies. The first one is called a healthcare power of attorney, and the second one is called a declaration of desire of natural death. These two documents were documents that were created by the General Assembly that essentially allow you to advise your doctor how and when you want to be treated when you're incapacitated. In other words, you can say, do not resuscitate me, or you can say, give me maximum treatment. These documents are very important because they tell your family and they tell your doctors how you want to be treated when you can't speak for yourself. The last document is a very important document, and it actually has a little bit of a twinge to it because it's different. It is a very powerful document called a financial power of attorney. That document's purpose is to allow you to authorize an agent to make financial decisions for you when you're not able to. Now, I said that document was a little bit different. For that document to be effective, it has to be recorded. And what I advise people to do is to go ahead, have the document signed, witnessed, and notarized, but let's put it aside. Let's don't record it. I worry about identity theft, and once it's recorded, anybody in the world that has access to the internet can pull a copy of it. So, in my practice, what we do is we have the financial power of attorney signed, witnessed, and notarized, and then we contact everyone named in the power of attorney, and if they reach out to us at a later time and say, Joe needs to have his financial power of attorney recorded, we can then record it at a later time and use it when it's needed. Again, the four basic documents are the last will and testament, a healthcare power of attorney, a declaration of desire of natural death, and a financial power of attorney.